I thank you for the kind introduction. My publishers thank you. Books available on Amazon.com. Good to see everybody. Good to see old friends. Good to see new friends. Good to see all the good work that AEN is doing. As Miriam has said, the Brandeis Center has been honored to work with AEN now for some years, and I've been pleased to work with Miriam even longer than that. I'm especially happy to speak with all of you, as I know that AEN faculty are often in the front lines, on the trenches, doing very difficult work. And I want to say I salute your courage and tenacity dealing with the problems that I know that you deal with. I wanted to start now, since we're in a particular week that has had a great deal of tragedy, by saying a word about Buffalo. Erwin Kotler, who just gave a magnificent presentation, talked about how anti-Semitism starts with the Jews but doesn't end with the Jews, and often reflects a sickness within society. There's certainly a great deal of sickness that we experienced just a few days ago when an 18-year-old college student shot over a dozen people in Buffalo, New York, most of them African Americans, in what is undoubtedly a major hate crime and a serial murder. The record, including his online material, is saturated with anti-Black racism. And there is considerable evidence that he chose the site of his crimes specifically because of the concentration of African Americans in that area. This was, I think, a reprehensible act of anti-Black racism, and the sort of thing that we need to confront because it is a human tragedy, and because those of us who care about anti-Semitism need also to care about and to fight back against all other forms of hate and bigotry. There's also another reason to look at this problem in Buffalo, because it also is related in other ways to the problems that we're talking about in this conference. That is to say, we now see increasing reports, and for those of us who looked at the manifesto before it was taken down from Google Docs, we see that his writings were saturated not just with anti-Black racism, but also with anti-Semitism and other forms of bigotry. And not only that, but his writing doesn't just come from a place in which he hates various sorts of minorities that include Blacks, Jews, and others. But beyond that, it comes from a particular approach, so-called replacement theory, which doesn't just hate Jews, but which rather develops a conspiracy theory under which Jews are masterminding a plot to replace white Christians with various minorities, including African Americans. And I mention that as a distinction because the role of anti-Semitism in this twisted mindset isn't incidental. And it doesn't just view Jews as one among a series of minorities at whom rage is directed, despite the fact that the killer deliberately chose African Americans as his victims. He had a worldview in which the Jewish conspiracy is central to what he views as one of the great evils of society. In other words, he acted from a genocidal Jewish conspiracy. And I think that there are many commentators who are now looking at that and looking at the replacement theory and looking at its place in white supremacy, and looking at it because it is a very clear example of what I think Erwin Kotler was describing as this notion that anti-Semitism begins with Jews but doesn't end with Jews. That is to say, an intense anti-Jewish conspiracy theory led to deliberate murder of at least 10 African Americans. There's also something that's potentially even deeper than the replacement theory. I wonder how many people here have already forgotten who is Frank James? Yeah, some of you have already forgotten, and I don't mean Jesse's brother, the outlaw from the 19th century. There was a Frank James who was a outlaw criminal. The very day before the Buffalo massacre, Frank James appeared in court in New York to plead not guilty to terrorism charges based on an incident in which just a month ago, he opened up several smoke canisters, gas canisters, within a Brooklyn subway train. Now you're remembering the N train incident, and then started shooting his gun at people. So this was just the prior month that Frank James started shooting up people. It wasn't heavily reported, but the fact is, I don't know if you were aware that James had as his social media moniker a handle that was based on a code for the initials of Adolf Hitler or Heil Hitler. And he too had writings that were saturated with anti-Semitism and which were based on the notion that Jews were not just white people, but were had particular characteristics and were working together to harm people like himself. He, in other words, was killing many people, primarily, so far as I'm aware, Gentiles, but based on a twisted mindset that itself appears to have included what one might describe as an anti-Jewish conspiracy theory. He was not a replacement theorist. He was not a white supremacist. He has been described in some media sources as having been a black supremacist or black identity theorist, coming from a position that, to the extent that it had ideological coherence, might be described as more on the left side of the spectrum. Earlier this year, I'm guessing most, probably everybody remembers Collierville, Texas. Now, it may be understandable that when Gentiles were attacked in both Buffalo and Brooklyn, the notion of anti-Semitism and anti-Semitic conspiracy theory was sort of downplayed. But in Collierville, a hostage taker invaded a synagogue for the particular purpose of getting Jews, including a rabbi and several parishioners whom he took as hostage. And it was because he wanted to get influence to help release a terrorist who had been convicted, a terrorist who had spoken widely and who had undoubtedly a kind of anti-Jewish conspiracy theory. Even in this case, in Collierville, where the criminal made clear that he was choosing a synagogue as his crime scene and who took as hostage a rabbi and some congregants. Even there was downplaying initially of whether this should be considered an anti-Semitic matter or not. And so we have here, within the space of just a few months, three somewhat horrific tragedies involving what you might say roughly were left-wing, right-wing, and Islamist anti-Jewish conspiracy theorists who were engaged in attacking a significant number of people. In one case, Jewish people. In another case, people who are thought to be a part of the Jewish conspiracy. And in a third case, people who were thought to traffic through their work or residence in the location in which Jews were thought to be. So these three, it's not as if every one of the crimes we've seen lately involves this, but we are seeing the left wing, we are seeing the right wing, we are seeing both white and black supremacy, and we are seeing Islamism. Some of the discussion in the last few days focuses on one or the other aspect of this, replacement theory. I think it is good that the media is looking at replacement theory, but I think we also need to understand that all of these are part of a broader pattern right now, which is to say violence within our society, including serial murders, that are motivated by this hateful anti-Jewish conspiracy theory. And I think we need to be awake to it because it is growing, because it is lethal, because it is dangerous. This is not what we're seeing necessarily on campus, but I don't believe it's entirely different than what we're seeing on campus, which is to say, it may be that on campus we're not seeing this sort of mass murder, of course. It may be that you are not seeing replacement theory among students or faculty members at your institution. But we are certainly seeing in many places aspects of what you might call a Jewish conspiracy theory, certainly with respect to Israel, and also in some circles more broadly with respect to Jews' participation, supposedly, in a system of white supremacy. We're seeing in various places, maybe not the level of violence, but we're seeing something that is sufficiently close that I think it should give us pause. I have been working on the issue of anti-Semitism and fighting anti-Semitism on college campuses for roughly the period of time that was described in Erwin Kotler's talk, which is to say the last 21 or so years since the onset of the Second Intifada, 9/11, Durban, and what I would say the rise of the new anti-Semitism. And when I began this work, it was not because I thought that the problems that Jewish students or professors were facing then were so great that they merited really focusing one's life on it. There were students who were facing a significant problem, students who were transferring out or dropping out of their college because of the problems that they faced in particular colleges. Over the years, I've worked with students who were punched in the face and had bones broken and were otherwise attacked. But then again, it was not huge numbers. Generally speaking, the reason that I got involved, to the extent that I have 20 years ago, was more the trajectory than the snapshot. That is to say, it was more the concern that after some 50 years of progress following the end of the Second World War, we were no longer in a position where we could say with confidence that we were making progress against anti-Semitism, that in fact, there seemed to be at best a pause in our progress and at worst a reversal. So what I'm looking at is not just the problems that we see today, but with some fear and terror at the prospect that if we don't take action, it is going to be a reversal. Now, what we are seeing on campus today is a little different than 20 or even 10 years ago. Certainly over the last year or two, COVID has had a significant impact, but it's not had the impact that we had hoped. There was perhaps initially a question of whether there would be campus anti-Semitism on COVID-closed campuses. The answer, unfortunately, turned out to be yes. Yes, because there were still students and others in proximity, physical proximity, and so there were face-to-face problems. But also yes, because when campus went online, anti-Semitism went online as well. And that meant that we saw increasingly online anti-Semitism, which might be Zoom bombing, which involved both students and non-students, and sometimes that would have right-wing anti-Semite Zoom bombing with swastikas and others. It also meant that anti-Semites, including certain anti-Zionists, would use the online mode to organize in a way that was not just more intensive, but involved, I would say, the greater coarseness that we often saw within society over the last couple of years as we've become both more polarized and also as nerves have become frayed during the quarantine and post-quarantine phases. But we've also seen a few trends that have been especially disturbing that have continued the prior problems, but also exacerbated them. One is what I would call erasure. You're familiar with the term erasive anti-Semitism. This is the notion that in many cases, Jewish identity is denied or diminished or minimized, even within contexts in which other identities are celebrated or praised. It's not just that your institution might not have a celebration of Jewish Heritage Month this month, although it recognizes Heritage Month for other groups. It's also much more specifically that Jewish identity is denied in sometimes more explicit ways. For instance, in the Stanford University case that we have now before the EEOC, where mental health professionals were being trained to support potentially traumatized students facing various forms of hate and bias. And the mental health professionals asked, well, this is great. Let's talk about how we can do that. Would you like to also help us to think about how Jewish students might deal with the swastikas that they've very recently seen? And the answer was no. The answer was no, we don't want to deal with that issue because it detracts from some of the other anti-racism that we're dealing with other groups. And not only were they told no, but they were told that they shouldn't identify as Jews, but rather as either white passing, or white adjacent. They should join white-only affinity groups in order to own their white privilege. Now, this is in part an erasure of who they are, sometimes an imposition of an identity that they may not have chosen. But it's a little worse than that, because it doesn't just normalize them in a sense by saying, well, we're not going to hate you as Jews, we're just going to hate you as whites, or some such thing. Because Jews don't get to be just white. Jews get to be hyper white. That is to say, Jewish professionals are viewed as being presumptively highly privileged, highly powerful, with a great deal of control over what's being done in academia and elsewhere. So on that campus and elsewhere, what we've seen is that the erasure denies actual Jewish identity, heritage, and legacy, but replaces it with a particular form of whiteness, which is considered to be especially connected to evil. In our Brooklyn College case, which is now pending before the U.S. Department of Education's Office for Civil Rights, one of our clients reported to the media that she was told that it doesn't matter that she's Hispanic. The color of her skin doesn't matter. The fact it won't save her, was the quote, because she's Jewish. And so she therefore needs to own her privilege. Jewish hyper-whiteness runs quite deep on many college campuses. So we're seeing an erasure of Jewish identity as it exists in the lived experience of Jewish Americans and in the history of Jewish heritage, and a replacement with something that is much more sinister. Second, anti-normalization. The notion that Jewish student organizations, and even Jewish students, and certainly Jewish national organizations, should not be welcomed within the society of the good, should not be able to participate, for example, with progressive organizations in various ways. At San Francisco State, for instance, being told that Jewish groups should not participate in a Know Your Rights fair, except for anti-Israel Jewish organizations. And in other places, Jewish student organizations saying we will not work with various Jewish student groups, not just conservative Jewish groups, but also progressive Jewish groups. The notion is that if you are a Jewish student or Jewish organization, you can participate with certain other groups only on the condition that you enter into a contract. You have to at least make some statement disassociating yourself with Israel. Now, for many Jewish students and organizations, that's not just a political statement they're being forced to make. It is also an affront to something that they consider deep within their Jewish identity. Not all Jewish students or Jewish Americans generally consider Zionism to be a part of their identity, but many of them do. And for those who do, it's often a deep part of their identity, who they are. And they're being asked essentially to choose between this aspect of their Jewish identity, or perhaps a support for progressive politics, or simply a desire to assimilate within what has become increasingly a dominant mode within Jewish student life. This is particularly difficult for those Jewish students, or I know some faculty who associate themselves as being politically progressive, but especially so for some categories of Jewish students. For example, we work with there are Jewish students we work with who have associated themselves as part of the LGBTQ community. In some cases, they consider the LGBTQ community within their school to be an important source of support for themselves. And so it's especially difficult when those spaces become anti-Zionist and unwelcoming to them. Because then there is essentially no place where they feel is safe or comfortable for themselves emotionally. It's been even worse, and this is a particularly difficult topic I'm going to raise now, for those students who have been survivors of sexual violence. and who find that on some campuses there are survivor groups that have become anti-Zionist. And so therefore a group that they feel they need to go to for support at a time when they feel great pain and vulnerability is not open to them. So there are, I would say, for all Jewish students, some real significant problems right now, but certain subgroups are feeling problems of great intensity and of a sort that I don't think would be tolerated if it was directed at other sorts of groups. The third I'll mention, together with erasive anti-Semitism and anti-normalization, is a targeting, an individual targeting. 20 years ago, much of what we saw was anti-Jewish speeches on campuses, anti-Semitic BDS activism. We would see around the phrase, around the edges of this, targeting particular students. So, for instance, there might be a pro-BDS event, and a woman would be on her bicycle or something, and she would have a Star of David, and she would be spit at. So we've seen Jewish students individually targeted, especially in the wake of anti-Israel activism, for many years. But we have definitely, over the last several months and the last couple of years, seen a much greater amount of targeting of individual students. That's especially if they are prominent within their college or university, for instance, in student government. It's especially if they also have some connection, some public connection with Israel, but it doesn't have to be a lot. There is a much greater, more intense targeting, including with impeachment efforts of anyone who is publicly connected to the Jewish community on campus. We saw that with the effort to impeach student government leader Max Price, our client Max Price at Tufts University, who successfully beat back an effort to impeach him, and also another client of ours, Rose Rich at University of Southern California. She ultimately resigned her position in student government, having been subjected to really extraordinarily awful mistreatment, but fortunately was able to successfully defeat the effort to impeach her. So over and over again, we've seen issues at UCLA and Stanford and elsewhere, that now increasingly, it's not just about creating a general atmosphere on campus that's hostile to Jewish students. It's also more and more targeting of individual students. It's targeting of Jewish groups like Hillel organizations, but it's also targeting of individual student governments, especially if they're influential. So what we're seeing is a harsh, personal set of attacks that builds upon and worsens the problems that we had seen on college campuses. The good news is that the fight back is happening. Certainly the Brandeis Center is stronger than it's ever been, and we're proud to work with groups like AEN that are strong at the faculty level. And there are other groups that are doing the right thing, including some groups that are run by students or recent graduates, as well as other national organizations that have gotten involved. So the fight back is happening. But we have a real challenge in dealing with it because there remains considerable denial. Even when anti-Semitism seems obvious, it's quickly denied, as we've seen in recent high-profile news situations, but we see it invariably on college campuses. Whenever there is any possibility to treat anything as being something other than anti-Semitic, it will be treated as something other than anti-Semitic. And often there is a stark refusal to deal with the hateful character of what's going on. At Georgetown Law Center, the day before Holocaust remembrance, there was a student who was brought in, a speaker who was brought in, who had a long record for anti-Semitic remarks, and despite lots of protests and criticism, that talk went on. There were requests that the president of the university make a public statement, and he finally did make a public statement. And his public statement is supportive of the community in Buffalo and critical of the state of Israel for what it's been doing. But as for a statement that's actually supportive of Jewish communities, that's a lot harder to find. Now, much of my work over the years has been in federal civil rights enforcement, and it never occurred to me when I started that work that I would be dealing with anti-Semitism. I always knew that the history of anti-Semitism would motivate me to want to deal with problems facing other groups, but I never expected that I would have to work so hard on dealing with anti-Semitism that has developed in this country over the last 20 years. Now, we've made some progress there, but with every 2 steps forward, there's a step back. It was some 18 years ago that I got OCR, the U.S. Department of Education's Office for Civil Rights, for the first time to acknowledge that Title VI of the Civil Rights Act of 1964, which prohibits discrimination on the basis of race, color, and national origin, protects Jewish Americans too, also Sikh Americans, Muslim Americans, et cetera, et cetera, et cetera. That was in 2004. But then for several years after I left, the agency was not following that and did not acknowledge that Jewish students were covered. It was only in 2010. It was only in 2010 that my successors in the Obama administration ratified that position, and that it was only in the last administration that the executive order on combating anti-Semitism codifies this notion that Jews are protected. Despite that agreement, there were several years in which OCR and other federal agencies were simply not dealing with anti-Semitism, except in a very, very small number of exceptions. There was almost nothing happening, and the general reason was that there was no standard, no example, no definition to guide the agency. And for that reason, even strong claims were rejected by the agency. That changed during my tenure, in part through cases that I handled at OCR, but also in part through the executive order, which, in addition to indicating that Jews are protected under Title VI, also directed federal agencies to use the OIRA working definition of anti-Semitism, which I know you're all familiar with because, among other things, Erwin Kotler has just been describing its importance in several respects. So we now have this, but it was an executive order of a former president now. So people ask, does it have any significance? And that's a big question. And it's a question that should be on our minds. All of President Trump's executive orders have been archived. Some of them have actually been rescinded. Fortunately, the executive order on combating anti-Semitism has not been rescinded. So while it's not on the active part of the White House website, it is active policy of the federal government, even more so because in the last days of the prior administration, OCR, the Office for Civil Rights, issued sub-regulatory guidance in the form of FAQs, frequently asked questions, that incorporate the executive order. That is to say, OCR used its own process to incorporate the executive order within its policies. And that guidance, those FAQs, remain on OCR's active policy portal. So in other words, despite the fact that the White House has merely archived it, the Department of Education's Office for Civil Rights, which has responsibility for enforcing this law, continues to signal to institutions that it's active. Although frankly, it doesn't signal it in a lot of other ways. You're not seeing a lot of speeches from OCR. You're not seeing technical assistance. You're not seeing a lot of signaling from this administration that they care about the issue. There's one possible exception to that. If I say OIRA, is there anybody here who's going to know what I mean? Nobody knows what OIRA is. Is that right? OIRA. Yeah. So I'll tell you, and you'll learn something from me now. You're familiar with the White House's Office of Management and Budget, or OMB, which is most famous for the budget portion, OMB. it's responsible for developing the president's proposed budget. But the M in OMB is management, which has various aspects, including oversight of regulations throughout the federal government, OMB. And the arm of OMB that deals with regulations is quite powerful, even if they're not an everyday word. The Office of Information and Regulatory Affairs is known here in Washington as OIRA. Very powerful. OIRA is the part of, technically, the White House, which twice a year issues something called the Unified Agenda and Regulatory Plan of the United States. You haven't been reading that? Yeah, nobody really reads it unless you're really focused on these issues. But it is an announcement twice a year by the White House of what they plan to do in the coming 6 months that has to do with regulations. When I was heading OCR, I requested of the White House, and they agreed, to include within the unified agenda that we would issue formal rulemaking on the executive order. That is to say, we would take the executive order, which we knew, executives change, and we would make it a part of a formal regulation, which would give it much more durability. It's a lot harder to rescind a regulation than it is to rescind an executive order. Rescinding an executive order is a stroke with a pen. Rescinding a regulation takes a formal process under the American Procedures Act that often takes many months and more likely takes years to accomplish, and Congress can intervene in that as well. So we indicated that we would do the rulemaking and then didn't have the time when the clock ran out and a new administration came out. And then the question was, well, what is the new administration going to do? Are they going to very quietly drop it off? And you wouldn't have noticed if they had, because you weren't following that. But the good news is they didn't. They didn't. They actually kept it on. And not only did they keep it on, but they did something that was kind of interesting. They changed it a little, which means they actually were reading it and thinking about it because they were editing it. And they said that they will do rulemaking on the executive order on combating anti-Semitism and President Biden's executive order on systemic racism. We don't know exactly what that means. If what it means, and based on some of the examples they gave, it could, if what it means is that they're going to address not just anti-Semitism, but other forms of discrimination against ethno-religious groups like Sikhs and Muslims, I think that's a good thing. I certainly did the same back in 2004 and would be pleased to see the government issuing a regulation that codifies that other groups also have protections under Title VI. But the important thing is that it not just codify that piece from 2004, but also the heart of the executive order, which is the working definition under IRA. So will they do that or not? Now, their deadline, the date they were going to do that by, was the beginning of this year. And we don't remember them doing it at the beginning of this year, do we? It's because they then sent another notice out from OIRA saying that they were running behind. They actually said that they were so concerned about Title IX problems that they were going to push up Title IX regulations. But when it came to anti-Semitism, even though we were seeing last year higher rates of anti-Semitism nationally and worldwide than in any recorded period, when it came to anti-Semitism, they were pushing it back until the end of December. Well, there's an optics question of why are you pushing it back if it's so important? But then again, December's not that far from now. So there's an open question now. The Biden administration is indicating in a way that has not gotten a huge amount of public attention that they plan to do formal rulemaking on the executive order on combating anti-Semitism, which could be extremely helpful if they do what I was planning to do, which is to say codifying IRA within regulations subject to appropriate First Amendment restraints. Could also be very bad if they as part of this process, replace the executive order with something that doesn't institutionalize the OIRA working definition. So in other words, the stakes are high and the time is happening quickly. This is something that they are apparently writing right now, that they will issue as a proposal on a date that they suggest at this point will be in early December or so, and which will be the subject of public comment, a formal process where you can write in, starting probably in early December. So keep an eye out for it, because they are going to be looking for public comments, especially from smart academics who know something about this topic. And you know they'll be getting lots of comments, including from people who are not concerned to fight anti-Semitism, but are instead more interested in fighting for anti-Semitism. So we all have a role, I think, if we care about this, because this is an issue that is very much up in the air. And having spoken to people within this administration, I think that there is a real possibility that they will do the right thing and that we will see a regulation coming from this administration, which is very strong. But that's not by any means a sure thing, because I know that they are being advised very strongly, adamantly, by people on their side of the political spectrum to do the wrong thing and to gut the executive order and to gut the policies of OCR. So in other words, we have an unusual situation now, which is that in the relatively near future, things in Washington could improve or substantially worsen, and we have the possibility of having impact. We've got time, but not endless amounts of time. And in the meantime, what else can we do? When we find hate and bias incidents on college campuses, the response from administrations, if they respond at all, is often that this should be addressed through the usual processes, often through their general DEI programs, diversity, equity, and inclusion. There are different offices within each university. Sometimes it's within student services, sometimes elsewhere. And I'll tell you that I've seen people within these parts of universities that mean well, but I've also seen some who do not. And oftentimes I see people go to these offices and they find that A, there's no interest in supporting them. B, if they file a complaint, they do not get a sympathetic ear. And in fact, they're treated like criminals for having gone to them. And the interest at some institutions seems to be in discrediting the complainants, putting them through another traumatic situation like the one they went through. And C, to the extent that individuals use these processes within the campus, it can undermine their ability to get federal remedies, more so for students than for faculty members. But the problem is that if they're interested in going to OCR with a complaint, OCR under Title VI will often dismiss a complaint if it's already been heard within a grievance process within the university. So what they have within this DEI program is often unsympathetic listeners who will sometimes make the situation worse for them, and who will do it in a way that potentially undermines any federal claims that they might otherwise have. Moreover, Erwin Kotler made an interesting point earlier, which is that DEI programs are sometimes worse than just unsympathetic. The problem isn't just that they will not do the right thing, but that they're sometimes doing the wrong thing. Now, there's scholarship, I suppose, going on both sides of this, but there certainly has been some recent work looking at DEI officers and suggesting that there is an intense amount of anti-Zionism among their tweets. I know that there's methodological disagreement among some people, but generally speaking, that's often true of high-profile work. It certainly is consistent with what we've seen, that DEI offices are often reflective of general trends among people who are concerned about civil and human rights. And those trends are not necessarily positive for Jewish students, which is to say the very people who are supposed supposed to help victims of hate and bias are sometimes peculiarly insensitive or even averse to the interest of the Jewish students. Now, sometimes that is explained as an aspect of left-wing anti-Semitism, because it's certainly not right-wing anti-Semitism that one sees within diversity, equity, and inclusion. But I see it as something else. It's not to say it isn't left-wing, but I see it as something potentially bigger. How many doctors do we have in the room? Medical doctors, I'm sorry. We're all doctors in some way or another. Okay, one, okay. Because I'm about to misuse, I'm not about to have a heart attack, don't worry. I might be about to misuse a medical term though. So I just wanted to know how much trouble I'm gonna be in. Correct me if I'm wrong, but I understand that some medical doctors use the term nosocomial to describe infections that one contracts in a hospital, but that the term also can be used more broadly to describe diseases that one contracts through instrumentalities or facilities that are intended to support health. I find this as a metaphor useful because what I am increasingly seeing is that not just Jewish students, but Jewish people are often being harmed in particular by instrumentalities that are intended or designed to address hate or bias. It's not just happenstance. When one sees, not just in the UN, but in the UN human rights arm, when one sees not just at universities, but in the DEI movement, when one sees not just in political movements, but within human rights movements and human rights organizations, there is a pattern. There is a pattern that some of the worst diseases, so to speak, of anti-Semitism that we're seeing right now are spread through the specific instrumentalities that are supposed to deal with the problem and that are in fact making it worse. I don't know how this metaphor is going to help, but here's what I'm going to say. To begin with, there are probably very few medical doctors, correct me if I'm wrong, who respond to nosocomial infections by saying, let's close the hospitals. Probably not many. But there are probably not many who say, well, let's respond by ignoring the problem and continue to operate using infected instruments. Generally speaking, it seems to me, and I know I'm on a little bit dangerous territory. Generally speaking, there's some protocol having to do with disinfecting the instruments with the appropriate agent at the appropriate dosage for an appropriate period of time or some such thing. When we see DEI programs unable to deal with anti-Semitism, and I'm thinking mostly at universities, but I got to tell you, we're seeing it more and more in the corporate world as well. One of the first things people say is, well, that's because they're not even dealing with anti-Semitism. And what we saw at Stanford is that they didn't want to deal with anti-Semitism, at least at one point in time. And I think that that's right. But I'm also concerned that the solution isn't just for them to say, okay, well, we'll deal with anti-Semitism. We will slot it in the same as we're dealing with all of the other things, because their instruments are infected. It requires more than just saying, okay, we will add a component to deal with anti-Semitism, but we're otherwise going to deal with the situation in exactly the same way that we've been dealing with it before. No, you can't do that. You need first to acknowledge and recognize that our instrumentalities to address these problems are thoroughly infected and they need to be disinfected. The namesake of my institution used to say that, or at least once famously said that, that sunlight is the best disinfectant. And I think that that's right. And the first step is to expose it when it's happening. But I also think that if he thought that sunlight was the only disinfectant, he probably wouldn't want to eat at his house either. I think that sunlight is the first step, but we also need not just to slot anti-Semitism in, but to address the underlying problem, not just within the campus and within the corporation, but within the particular bodies that are supposed to deal with it, but are in fact need to be cleansed before they can. So let me say in closing that we have on the one hand, a problem that is not just bad and getting worse, but that is connected in some significant ways to lethal incidents that we've seen and recently and in this country. That we have ways of fighting back, both within the Brandeis Center and among our friends and allies, and that's helping. But ultimately, success depends on our turning around, our cleansing the instrumentalities that are required to operate properly. That has to happen. Now, dealing with agencies like OCR is a part of how it can happen, but it has to happen not just in Washington, but within every university, within corporations and elsewhere. And that's why there is, not just for those of us in Washington, but for all of you and for everyone who cares about this, an important role, which, as I see it, will get not smaller, but bigger and more important in the months and years to come. I thank you. And I'd be delighted, especially if Rick Barton has one.
You can. Always good seeing you. So tell us a little bit about Brandeis and the process that you use when someone like a student or a faculty member calls you and says, here's the problem I have. How do you go about deciding when to get involved legally, when not to get involved? Can you give us an outline of exactly the process that you undertake?
Well, bless you, Rick. I love answering that question. That's great. It's my second favorite question too. How can we send you money? So as Rick Barton's question suggests, the Louis D. Brandeis Center in Washington, D.C. fights anti-Semitism through law and public policy. And that means that we represent often professors, staff members, and students who can come to us through our website, through KL Marcus at brandeiscenter.com, by asking Miriam Ellman to connect us, by asking you, Rick Barton, to connect us. We now, at one time, there was just one of us, and now two, and then three. So we now have a handful of lawyers who are available to work with professors, students, and staff members who have problems. I would say that if there is a problem on the campus, we as lawyers can very frequently do something, especially if people come to us early. Sometimes people think, well, let's not go to the lawyers until everything else has failed. And so they wait until their potential claims are time barred. And we say, well, there are lots of things we could have done. There are sometimes people come to us with a potential case that could be brought to court or to an administrative agency, and we do that. But we also help people, even if there isn't something that they want to bring or that we think would be sufficiently strong from an evidentiary or legal point of view. Oftentimes we can work with faculty members to frame their issues truthfully and persuasively in terms of the evidence in ways that will resonate with the administration, because they are connected to well-established legal rules under which the institution will be evaluated. So a great number of our matters involve helping professors and students to think through and strategize how they can communicate the issues in a way that make clear what they're facing, what is its severity, and how does it relate to the existing established legal duties that colleges are under. It is a much smaller subset that lead, for instance, to a formal letter, perhaps a public letter to the university, maybe where we get media attention and all the rest. And a smaller subset still that lead to a formal legal complaint that we might file with an administrative agency or within a court. But there are a host of issues in which we can help in one way or the other, depending on what's happening. Thank you. Please, Doctor. I think the question is whether I would comment on the role and duties of Ambassador Deborah Lipstadt, who was recently confirmed and appointed as the special envoy to monitor and combat anti-Semitism.
Yes, and will she be involved in the rewriting of this executive order as well.
Okay, let me start with the first part. And the second part is whether she would be involved in the rewriting of the executive order. And that's interesting as well. So Ambassador Lipstadt has a role that has existed since the George W. Bush administration, although it was very recently enhanced by Congress. And so she is the first special envoy to hold ambassadorial status. She's the first to be a presidential appointee, and she is the first to be congressionally confirmed. All of that matters. We've had a handful of special envoys from the George W. Bush administration to the present. In my humble opinion, they've all been strong in different ways. They have headed the office to monitor and combat global anti-Semitism within the State Department. They've had a small staff, which they've typically traveled around the world, certainly during non-COVID times, working with allies and others, gathering information about anti-Semitism, working with other countries about addressing it more effectively. They work through multinational organizations sometimes, like OSCE, the Organization for Security and Cooperation in Europe, in order to form coalitions that will do things like more broadly utilize the OIRA working definition for multiple administrations over time. In fact, for the whole time that we've had this office, I just say since the George W. Bush administration, these special envoys have advanced the working definition of anti-Semitism even before OIRA actually adopted it. So their work involves both monitoring, but as the name suggests, combating. And of course, they often articulate the successes of the administration to the administration's the stakeholders. So that's generally the role of the special envoy. Now the question is, will a special envoy have a role in doing something like handling the regulation? Well, that's complicated. Generally speaking, probably not, although it's hard to say. Deborah Lipstadt is a recognized authority on anti-Semitism, and maybe she will have even greater influence than her predecessors have. Generally speaking, agencies are separate. The domestic agencies don't necessarily answer to our foreign policy establishment. So it isn't generally the case that a cabinet level domestic agency would go to a State Department official, even a senior State Department official, to ask them how to rewrite their regulations. The Department of Education is required to work with someone within OMB. What's the agency? OIRA, that's right. OIRA. I've never been with a group of people, so many of whom know about OIRA. So they definitely deal with OIRA. They are required to deal with the Justice Department and its Civil Rights Division. State Department, maybe not. I would say that Special Envoy Ilan Carr was unusually influential and had perhaps a bigger informal role in a whole government response to anti-Semitism than his predecessors had. And that's not a knock on his predecessors, who were strong in other respects. But there are, and maybe Deborah Lipstadt will continue Ilan Carr's rather exceptional role. Maybe she'll build on it. It's too hard to say. That involves issues bigger than them, having to do with the politics of the different cabinet agencies. There have been at least two prominent proposals to enhance the role of that position still further, or at any rate to enhance coordination. Ilan Carr has publicly urged that the special envoy have a dual hatting, have a second role, perhaps within the White House Domestic Policy Council, under which she would be formally responsible for coordinating work across the agencies. If that were approved, and I think it's not a bad idea, she would have that authority. Tevi Troy, the former White House official and former Deputy Secretary of Health and Human Services, has argued that there should be a role like that, but it shouldn't be within the State Department. It should be within the Justice Department. There are also other models. Currently, we do not have in this country a single official who is responsible for coordinating responses to anti-Semitism, as they have had in some other countries like France. It wouldn't be a bad idea to develop such a coordinator. Yes.
Thank you. Yeah, so I've got a particular issue on my campus, and I'm wondering if I might generalize, which is there is a center for the study of rights and something. It's a rather kind of security, rights, and race. Thank you. And Miriam has been extremely helpful with this. And it is an adjunct of a center, an official center of the university. This is at Rutgers, that is dedicated to the promotion of especially the rights of Arab and Muslim peoples, which is legitimate. It's a fine agenda. The problem is that their focus seems to be excessively directed against Israel. So I have we have seen very little, nothing actually, about abuses anywhere else in the Arab world by any other sources against Arabs, or very little of that. And the vast predominance of issues has to do with the horrors of Israel. They have material which has questionable provenance. Looks like it comes from like Al-Haq and other sources that are certainly not academic. And then they promote their activities in a way that other centers on my campus do not. I mean, they flood the emails with what they're doing. But they seem to be sort of skirting a line of what is technically appropriate and what is by sort of de facto an anti-Israel agenda. Miriam, you got that sense as well, that this is not. With the small number of Jews on my campus, yes, do feel so. It feels like an oppressive institute with an agenda which is hostile, which can affect the climate in ways that are worrisome. But I believe that the faculty are from the law school, so I think they are very alert to what lines they can or cannot cross. But the effect is to have a very large population on this campus of students from the Middle East, is to make the campus a more tense, less friendly place and introduce speakers who are not scholarly, but have a very strong anti-Jewish, anti-Israel agenda. We don't know, we've communicated with the administration, we've let them know of our concerns, but other than doing that, is there, what might you recommend that we consider in a situation like this?
Well, I'm sorry you're going through this. Although I have to say, it is not the first time I've heard of problems at Rutgers University. So a couple of things to think about. One is sort of a broad view of looking at this within the question of the general climate and how it's been dealt with, as opposed to just within this particular center. A second is to think about how, as educators, people within the Rutgers community, scholars within the Rutgers community, can use it as an opportunity to provide a greater understanding of the problems that arise when one has this sort of one-sided approach. There are sometimes legal responses to problems at college campuses, but legal responses aren't always the best way to deal with it. It's true that your university does have a legal obligation to respond to climates that are hostile to Jewish students. But to the extent that there is hostility on that campus, it's not just because of this one institution. And to the extent that this one institution, this one center, is making the problems worse, the answer, of course, isn't to close the institution or to tell them to stop doing this or that, perhaps to inform them of some of the ramifications of what they're doing. Certainly one should consider counter-programming, but counter-program doesn't necessarily mean they say something that's both anti-Israel and anti-Semitic. And so someone says something that's pro-Israel and not anti-Semitic. It's not just a matter of addressing canards about Israel. It's also about addressing anti-Semitism and the forms in which it takes. So I think it's particularly important that an institution like this, that there be focused attention, including scholarly attention and speakers and all the rest of it, to the problems that can arise then. And so maybe think of it as a positive opportunity to say, we at our institution above all should be taking the lead to understand, to explain, and to teach about this problem of anti-Semitism that some have felt is making things worse for them here. There's a question here. Sure.
So I want to see if you have something to say about the Jewish faculty and staff on campus who have been driven underground by the campus climate. I'm one who is not driven underground, as you can see. I'm above ground with all these other people. But a lot of people have been, and so students come to a campus where there isn't kind of cultural leadership from faculty, at least on my campus, and I know that's true of other places as well. So what I'm wondering is if you have any framing to offer to help people to kind of come back out come out of the closet, in a sense, as Jewish people in the public square, and to kind of live in an awareness together, and when necessary to act in ways that we need to act. But I feel like before there's any action, there has to be some willingness to just kind of admit that we're Jewish people and that we have something in common that's important to us. On my campus, I'm literally the only faculty member who does that. The others have been driven, wasn't always this way, but they've been driven underground by 20 years of virulent boycott movement stuff, really ugly, nasty stuff from their colleagues. And now there's kind of an opening, for reasons I won't get into, where there's an opportunity to reopen some things. And I'm just looking for some new way to frame things. And one of the reasons I think you might have something to say about it is because there's something kind of cool about the law, you know? And so I'm just wondering if there's and I mean cool in both senses, you know, groovy cool, but also just dispassionate in a way. And so I'm just wondering if you have something comes to mind.
Let me say a few words about it, but I think that's a terrific question, and it could be that there are other folks who also have ideas who deal with aspects of it that are different than the legal approach. First, we're seeing the problem that you just described. I mean, we just did a survey in conjunction with the AEPI and AEPhi fraternity and sorority of Jewish experience. You saw that? So, you know, we were surveying not just Jewish students, but students who almost by definition have some degree of self-identification. If you're looking to hide your identity, you don't join a Jewish fraternity or sorority where whenever anybody asks you where you live, you're basically outing yourself, right? So this is a group of people who are, generally speaking, quite self-identified and comfortable expressing who they are Jewishly. And what we found was a remarkable percentage have felt they needed to cover or hide their Jewish identity. And not only that, but they do it more with each year that they're there. That is to say, by the time they're seniors and they've been around a little bit, they feel they really need to be careful about who they tell they're Jewish. So this isn't a case where either Jewish day schools or Hebrew school or somebody has told high school students, you know, there are all these problems on campus, but by the time they get to the campus, they find out, oh no, things aren't as bad. It's just the opposite of that. It's that these students come to campus not realizing how bad things are going to get. And the longer that they are there, the worse they view the environment on campus, and the more they feel they have to be careful about what they say and do Jewishly. So a couple things on that. And this may go to the Rutgers question as well. You know, if you're at a university that doesn't celebrate Jewish Heritage Month, and the chances are maybe not 100% that you are, but if it's not 100%, it's probably close. Then the question for the administration is why not? And then maybe ask them, well, does this mean that you also don't celebrate, and then tick off a whole bunch of other heritage months that you know that they celebrate? So, I mean, there can be ways that the university can get behind things that are uncontroversially and easily positive, and they should. Now, I don't think that having, hummus and pita bread is going to solve and anti-Semitism, but I do think that doing various things that sustain positive attitudes towards Jewishness, both among Jewish students and among others, is a very positive thing. It's a very important thing. So I would say it's very good to have things that are non-threatening, that everyone can come around and get, and that are, that project a positive sense of Jewish community and Jewish identity. And then perhaps moving that, on the spectrum as your environment, permits, having things that build on that with maybe deeper understandings of Jewish identity, including things that have nothing to do with Israel and things that do have to do with Israel. And then might also include issues of civil rights and perhaps coalitional approaches to civil rights. For instance, our Brandeis Center chapter at the University of Pennsylvania a couple of years ago had led a session together with an African-American group on Title VI protections for African-American, Jewish, and other minority students. Or there are other ways to sort of cooperate on shared things, and then you can build on that. But I think it's sadly important to even get the basics right, so people feel comfortable about that, and so that in time they can do things like feeling that they can walk around with a Star of David without being judged or attacked, or maybe having Hebrew lettering on a T-shirt, which used to be fairly easy and uncontroversial, or maybe even things that are a little bit more expressive of their Zionist identity, if that is how they express their identity. Sure.
We have our final question over here, Ken.
Hi, Ken. Thank you so much.
Sure. Hi, Rob.
Yeah, law is cool. Speaking about, people going underground, I was just at my law school reunion, and one of my colleagues talking about this project, Anti-Semitism. One of my classmates said, 75% of our professors were Jewish. And I said, and during our 3 years, how many times did you hear the word Jew mentioned in the classroom? And no one could think of a single instance, except where a professor mispronounced Aronson as Ehrenberg, but okay. So, and Ken's familiar with our project, this Law versus Anti-Semitism project, which is designed to throw a lifeline to all the Jewish professors for whom there is, for all the reasons we've discussed, no professional upside to identifying as Jewish, by providing a hook, and the hook being, guess what? There's a course you can teach on Jews, anti-Semitism, the law, and you can teach it, and here are our curriculum, and guess what? You're going to have students who are going to be interested in taking that class, and those students are going to go work with Ken when they graduate, and work, with other organizations, and even the classes themselves at the law schools will be, it's like teaching a Hebrew class, having like a class where Jewish students will show up. It's not just educational, it's socialization. So we're working on this, sort of making law schools more friendly and producing Jews who will come out knowledgeable and motivated to, work on behalf of the Jewish community. That's my pitch. Back to what you're saying. So it sounds like the regulations from the Department of Education are incorporating by reference the OIRA definition.
The existing sub-regulatory guidance does that, and the indication from OIRA is that the future rulemaking will do that as well, but we'll see what they do.
And OIRA again is what?
The Oh.
Just kidding. Okay. So my question is, so what does that mean
Very good.
operationally to incorporate, because the IRA is not a legal document.
I'm sorry, you said.
IRA is not a legal document. It's not a legal definition. It has its own, it has purposes, but it's not, you don't hand this to, typically it's not directed to legislators, is it?
So lots of people say that the IRA working definition of anti-Semitism is non-binding, not legally binding. I consider that to be at best simplistic and perhaps wrong. Now, there's good reason why they say that the IRA working definition of anti-Semitism is non-binding. And that's because the IRA working definition of anti-Semitism says this is non-binding, that the word non-binding is actually part of it. So it's understandable why someone say, oh, this is the non-binding definition of anti-Semitism. And it's non-binding in a critical respect. IRA, as a multinational organization, cannot bind its member states. And if it had tried to do so, if it had said, this is a binding definition upon our members, it would have been, I would argue, an inappropriate encroachment upon the national sovereignty of its various member states. At a minimum, it would have had to be treated as a treaty, and each country has a different process for ratifying treaties, but we would have had to go through that process. And we haven't gone through that process. So it was, from the perspective of IRA, non-binding. Now, they didn't say this is a definition which can never become binding. It's a definition. People can do with it, countries can do with it as they will. So what have they done with it? Well, countries have done different things with it. Some have argued, I'm not a Romanian lawyer, but some have argued that Romania made it binding upon its universities by some actions it took. In the United States, it seems to me it's clearly binding in certain respects. For example, to the extent that certain states, whether Texas or Florida or elsewhere, have passed state IRA bills, some of those bills or resolutions have been non-binding, but others haven't. You have to read each one of them. And some of them have actually made the definition binding upon certain institutions, including universities within the state. So I believe that it is quite definitely binding within those states that have state IRA statutes of a particular kind. So at a state level. At a federal level, the executive order, as I mentioned, has been incorporated within subregulatory guidance, under which OCR is saying that it will use the IRA definition in evaluating whether its recipient institutions, which I think pretty much all of you work for, it's nearly every college or university in the United States, it will, in evaluating whether they are complying or not complying. So in other words, it will use it in a way that is certainly similar, if not identical, to the way in which it uses statutes, court cases, and other things. If your regulator says, these are the standards we are going to use in applying a statute which governs your conduct, then they're saying that from the perspective, at least of the administrative apparatus of the government, this is how we are viewing the law. It becomes binding to that extent. Oh, so let me just, it's a little more than that even, I think. Now, it's an administrative agency. Whether it will then get deference, judicial deference by a court is another question. And one could argue back and forth whether it would, although I have to say subregulatory guidance from OCR often do get full judicial deference from the courts. For instance, the three-part test under Title IX is purely a product of similar subregulatory guidance, and it is considered law in the United States. It's been it has been recognized by various courts, but very few cases go to the courts, whereas there might be 10,000 cases going to OCR. So it is part of the administrative apparatus, and moreover, virtually every college and university signs grant conditions. It signs assurances to the Department of Education on a regular basis saying that in taking your money, we will follow those statutes and regulations over which you have jurisdiction. And OCR is saying in a very formal way that Title VI should be interpreted in this way. So I think that it can at least be argued that your university, wherever you are, has assured the government that it is complying with Title VI, including its regulations, as interpreted by OCR through the sub-regulatory guidance incorporating OIRA. So I think that there are some important respects in which it is now binding through the assurances that universities provide, through the regulatory or sub-regulatory structure of OCR, and through what various states are doing.